Hello, and welcome to the Nell O'Connor-Danowitz Knowledge Series. My name is Nicole Wiesa, and I thank you for joining us. Today, I will be presenting Volume 2 of Keeping in Touch with Legal Updates. My presentation today is entitled The State of the Illinois Workers' Compensation Commission, and I intend to provide you with both procedural and substantive updates as to the current state of the Commission. Please note that any legal information we've provided today is solely to be information-based and is not to provide you with any formal legal information or representation. If, however, you would like a consultation or like to further discuss anything that we presented for you today, please feel free to contact our office, and any of our attorneys would be happy to further discuss with you. So first, I'm going to discuss the current procedural status at the Illinois Workers' Compensation Commission. As many of you are aware, things have changed quite a bit in how the cases are being handled at the Illinois Workers' Compensation Commission. I'd like to first point out that as of November 13th, 2020, at 5 o'clock, the Commission has suspended all in-person activity that would include any trials, any pro se hearings, and really any reason you'd need to go to the Commission. All in-person has been suspended through the end of November of 2020. We will be looking to provide further updates once we have additional direction from the Commission, but at this time, that is the current mandate. In the interim, we will continue doing remote access, including all pretrials, and any and all or arguments will also be continuing by phone. So as I'm sure many of you know, for many months, the Commission has been handling a lot of the correspondence and the hearings through through the program called WebEx. So all of the status calls for Chicago and for downstate have been handled via WebEx. During the status call, each arbitrator handles things a little differently, but assigns the case, any case with a motion, a date and a pretrial setting. Any case that does not receive a pretrial setting, please note, is automatically continued to the next status call. This is a little bit different than our usual protocol, particularly for the red line cases. It used to be that any case which was above the red line was either automatically assigned a trial date, or if no party presented to the status call, the case would be dismissed. In light of these new special arbitration proceedings, that has been changed. So what do you want to do if you're looking to get a pretrial? So some of the rules have remained the same. There are some tweaks though. The 15-day notice rule of any motion is still in play. So please note, if you're looking to get a pretrial date, you do have to provide your opponent and the arbitrator with notice of the motion 15 days prior to the status call. The only recent change to that is that the Commission has declared the motions do not have to be formally file stamped. There's been a lot of problems and issues with the U.S. Postal Service and mail getting where it needs to go. So the Commission, in order to address that, said motions still have to be presented by 15 days, but not with a file stamp. Now, something that is different is that any motion you properly file within 15 days also has to be presented to the other side and the arbitrator by email 2 days prior to the status call. We are seeing a lot of arbitrators are following this very stringently, and let me clarify that is 2 business days prior to the status call. Some are following it a little more lax, but for the most part, just make sure any motion that you send off, that you do provide it within 48 hours, and any earlier is fine as well, before the status call date. So another rule is that I've been talking about these pretrials. So another part of the special proceedings is that every case will have to be pretried before any trials are provided, trial dates are provided. This is usually the first 5 days of the Chicago arbitrators trial cycle, with the last 3 being trial dates, and then downstate it does vary. Each of these pretrials is usually fairly quick, 10 to 15 minutes, but it is when the arbitrator will determine the issues, talk about any potential resolution of those issues, and determine if the case is to be certified for an in-person trial. Again, the purpose here is to try and keep as much in-person activity and interaction as low as possible, given the current state of the pandemic. If your case does receive a trial date, there are some additional rules. The date and time are provided with the attempt to try and keep as few people as possible at any of the venues and for little overlap. The rules have become a little bit less stringent for the number of witnesses and the time frame, so that people are allowed to put on their full cases, which is obviously very great. but also any individuals appearing for trial are expected to wear masks and remain as socially distanced as possible. All of these new procedures have been put in play, again, for everyone's safety, and for the most part, we're finding it's working quite well. I would just recommend make sure if you want to or need to have an issue heard, be on top of getting motions filed, really try to follow these rules, and keep in mind that the arbitrators have some different and varying rules. If you have any questions about that, please reach out to our office, as we are keeping track of the various arbitrator procedural rules and handlings. And just from the defense side, we don't have as often to get our motions in front of those judges. So just make sure to follow the rules and make sure to get those notices out as soon as you can. So the next piece I'm going to discuss is a substantive update with a recent Illinois Supreme Court case. Now, those of us of the work comp bar have been watching this case very closely. It's the case of Kevin McAllister versus the Illinois Workers' Compensation Commission. And sadly, no, this has nothing to do with the movie Home Alone. I'm sure many of you will be watching that movie, though, soon with the upcoming holidays. Rather, this is a case about an individual who had an instance where he was getting up from the ground while doing some tasks at work. And ultimately, this case went from the arbitration level through the Supreme Court in looking at the issue of arising out of. Ultimately, the Supreme Court found the injury was compensable and overturned all prior findings of non-compensability, finding that was against the manifest weight of the evidence. So just briefly, I'm going to go through the case facts. Again, Kevin McAllister was working at a restaurant called North Pond. He was a sous chef. And in August of 2014, he was going to help prepare the sous chef station for the evening when another individual told him that a pan of carrots seemed to be missing from the cooler. As such, Kevin went into the cooler, he went to look for this pan of carrots, and in looking on the various shelves, he bent down onto the ground. When he was going to get up from the bending position, he felt a pop and a locking sensation in his knee. As a result, he sought treatment. He had an MRI, underwent conservative care, and ultimately surgery. Funnily enough, by September 15th of 2014, only about a month and a half after his accident, he was back at work and released to full duty. The issues in this case, again, though, were not with the nature of his treatment or the type of injury that he received, but rather the main issue is with, did his accident arise out of his employment? So procedurally, the arbitrator found initially that it did and awarded compensation. That was obviously ultimately appealed, and at the commission, the finding was that the action did not arise out of the employment. That holding was confirmed by the circuit court and the appellate court. Ultimately, the Supreme Court did allow for this appeal in order to take a look at this issue, and found that the arbitrator was actually ultimately right in finding that the act that he was involved in when he had the injury did arise out of his employment. So again, the sole issue we're looking at is, did this arise out of his employment? So the analysis that the Supreme Court went through involved first looking at the various categories of risk. So I've set them out here before you. First, we have the employment risks. That's the obvious. We know that if something is found to be an employment-related risk, it's going to be a compensable case. The Supreme Court made sure to point out and look back at the Caterpillar tractor case, which set forth the three sort of subsections of these employment risks. And these are important. The first one is acts that are instructed to be performed by an employer. Then we have acts that are a common law or a statutory duty to perform for the employer. And then lastly, are acts that the employee might reasonably be expected to perform incidental to his or her employment. And I've highlighted this on the presentation because this is really where this case turned. Now, the other two categories of risk that we have are personal risks, which are usually found non-compensable. Those are things like something personal to the individual, like a prior knee or a bad knee, or seizures, or some kind of condition due to medications that individual takes. Those are personal, usually not found compensable. Now, our third category of risk is neutral risks. And as we all know, based on some of the recent cases, including the Adcock case, the appellate court has found that neutral risks, which wouldn't normally be found compensable, can be found compensable, but you have to do an additional qualitative or quantitative analysis Now, one of the activities that has been put into the neutral risk category and that we've seen this analysis is with actions like the common bodily movements we see, such as sitting, standing, bending, things like that. So let's next look at the Supreme Court's analysis. We have to look at what category of risk was the petitioner involved with as he was kneeling and then standing up looking for these carrots. So as I said before, the arbitrator found there was a distinct straight employment risk. The commission said, actually, no, that was a neutral risk, and found that there was no greater degree of the petitioner getting up from the bended state than the general public. And that would be along the lines of the analysis from the Adcock case. Again, the circuit court agreed with the commission, and then the appellate court ultimately also agreed. Now, what's interesting is that the appellate court provided us with a couple of different analyses in their opinion. The majority found the risk posed by the act of standing from kneeling while looking for something that had been misplaced by a coworker was arguably not distinctly related to his employment. So that finding took his action completely out of the employment-related category. Now, in a special concurrence, a few of the justices found that when performing an everyday activity, again, such as standing, kneeling, bending, could be compensable if one was required to do that more than the general public. And they pointed out that the petitioner did not prove that he did that. So the Supreme Court came in and took a look and said, we think everyone's missed a little bit of a step here. So the Supreme Court said, let's not forget, when assessing a common bodily movement or an everyday activity, you first have to look at the caterpillar tractor components of a work-related risk and see if that comes first. So you have to, again, look and see, was it distinctly related to the employment? They found that it was, with him being a sous chef, and they found also that he was reasonably expected to go and try to help a coworker by the act of searching for these carrots as a part of his employment. The testimony showed that one of the job duties for this individual was to arrange things in the cooler. So that, coupled with the fact he was assisting someone in their job as part of his everyday duties, they found that that rose to the level of making the action an inherently employment-related risk. So basically, what the court has said here is the appellate court went a little bit too far. That first, if you have a common bodily movement, you can't skip over looking to see if it was an employment-related risk and go to the neutral risk analysis of whether the individual did it more than the general public. They said, first, what is the purpose of that action? Again, in this case, they said, ultimately, the act of looking for those carrots was helping a coworker, that was in the realm of things he was doing to further things for his employer. All of those made this an employment-related risk. They said, look, do this first. You must look to the employment relatedness. And then if that can't be found, then you can go to the neutral risk analysis. So ultimately, the Supreme Court said the appellate court missed a step, that they went a little bit too far, and that a little bit further deep dive, if you will, into the facts and relation to work was needed. So what we take away from this is that not only did the court overturn the Adcock case and applying of common bodily movements under the neutral risk analysis, but also every time now you have a case where an individual is getting up from their chair, is bending over, or doing some kind of activity that we think might not be greater than the general public, first you have to take a look as to why they were doing that activity and what was the ultimate purpose. This is going to change the way that we address compensability for some of our cases. We would suggest that a very comprehensive analysis and review is done early on with any case like this where you might think they were not doing the activity any more than the general public, and applying a neutral risk analysis. Again, if at any time you have any questions with a case or any facts of a matter that you're handling, we would always be happy to further discuss and help apply some of these new, this new standard that is now going to be something we are all going to have to live with as we go forward. So in conclusion, I just want to say thank you very much for joining us today. It has been a pleasure being allowed to present. As we all know, the defense of any workers' compensation or civil liability case requires a very careful, detailed evaluation of the facts and the law. And again, we're always here to assist with any assessment and provide any insight that you might require. So thank you again, and we'll see you at the next webinar.